Sveicināti visi atpakaļ patentu valdes organizētajā.
Hello again to the Intellectual Property Law Seminar organized by the Patent Board. Before I give the floor to the next speaker from the EUIPO, Erling Vestergaard, I would like to remind that if you would like to listen to the translation or interpretation of the seminar, please click on the interpretation button on the left side. If you would like to listen to the original, please click on original. As the remaining presentations will be in the English language, if you prefer to listen in Latvian, please click on interpretation. The next speaker, Erling Vestergaard, who has worked for 32 years as a lawyer in Denmark, of which he has been a prosecutor for 20 years. And since 2006, he has specialized in criminal cases of intellectual property. Since 2014, he works for the EUIPO, and he takes special interest in implementation of the intellectual property rights, in particular considering the impact of modern technologies. He has already participated in our seminars, and I'm very happy to give the floor to him again.
Thanks a lot for the invitation. And as it was said, I have enjoyed being invited to this seminar several times. I hope next year maybe we can have the seminar and meet in person. I certainly miss many of my good friends in Latvia, including the previous speaker, Sana Petersona, that I have known for many years. I will launch my slides now, and I hope you can see it. I will be talking about the impact of trademark reputation in civil and criminal trademark infringement cases. Have a little bit of a history in the beginning. I will introduce my own typology of the different types of trademark infringements and talk a little bit about enforcement measures in regards to trademarks with a reputation. But as we have already heard a quite extensive presentation on the civil remedies, then I will go quite quickly over that. Then I have a number of case examples. My civil case examples are all from Denmark. It's easier for me to take such examples as I come from Denmark, but my criminal examples are more international. And then I hope you will enjoy my last slide, my conclusion slide. I really worked hard on that to try to sum up everything that I will be saying. So that's the extent of my presentation. If we go back to the 1800s, trademark laws usually focused on fraudulent imitations, aiming at misleading the consumers. For instance, the French trademark law of 1857. And often in jurisprudence, similarity of goods was limited to strictly substitutable goods. However, interestingly enough, in 1868, a Paris court noted that a trademark is the distinctive sign of a good that serves to guarantee its quality, reputation, not only its origin. The first recognition of an extended protection of trademarks with a reputation came in the Paris Commercial Court in 1891, and it was confirmed in an appeal ruling the year after. The company Bureau Veritas, that was doing information services about sea vessels, protested against the use of Agence Veritas for commercial information services. The court found that the areas of service were clearly different, but there were some analogies in the services. But they noted that the name Agence Veritas was usurped with the purpose of taking advantage of the indisputable notoriety of Bureau Veritas. According to the court, the similarity between the brands caused confusion. The decision stood alone in French jurisprudence until 1930. On the 23rd of November 1937, the Court of Appeal in Paris extended the protection of Parisois for newspaper that was a very well-known newspaper, to use with totally different goods, aperitifs, without finding a likelihood of confusion for consumers. Of course, the most quoted turning point in trademark history in this field was the High Court ruling from the UK from 1898 in the Kodak case. The Eastman Photographic Company that produced cameras brought action against the Kodak Cycle company selling bicycles. The court found confusion was created outside the specialty, since the goods were often sold in the same type of shops. The line of the decision was quickly followed in jurisprudence in Scandinavia, Netherlands, Italy, and most notably, of course, in the United States in the 1920s. We have decisions for Rolls-Royce used for radio sets, Vogue used for headgear, and Dunhill used for shirts. Something very important happened in the 1950s. Our societies changed fundamentally, and that happened through the creation of new medias of mass communication, most notably television. The advertising function grew very important as major brands could reach millions of people, and trademarks could evolve into what Hélène Portet has called powers in themselves. Case law in many jurisdictions also evolved. It began applying terms like dilution, whittling away and blurring, or on the other hand, tarnishment and degradation. Very notably, from German case law, the German Federal Court in 1955, in the Magirius case, found a danger of blurring of the attractive power of a unique trademark, even if any danger of confusion was excluded due to the totally different nature of the goods. Legislatively, on the international field, the Paris Convention was updated in 1958, and we got the introduction of the new provision in Article 6 bis about well-known marks that created a protection against trademark hijacking of such well-known marks. From the 1970s, world trade grew, and with the fall of the Soviet Union, real globalization emerged. And as a result of that, we got the creation of the World Trade Organization. And as part of the World Trade Organization, we had introduced the trade-related aspects of intellectual property rights agreement. And that agreement was very significant, because it's very significant in many areas. It covered both protection issues and enforcement issues. And for well-known trademarks, it introduced a stronger protection in Article 16.2. It, first of all, incorporated Article 6 bis of the Paris Convention, so that article became part of the World Trade Organization's dispute resolution system, which is very important. But it also extended the protection to services and to non-similar marks if the use would indicate a connection between those goods or services and the owner of the registered trademark, and provided that the interest of the owner of the registered trademarks were likely to be damaged by such use. This was a very important international turning point. Later, we got a definition in the WIPO recommendation in 1999, the definition of what a well-known mark actually is. Following the TRIPS principles, the first EU trademark regulation in Article 9.1c provided protection against identical or similar marks with regards to non-similar goods and services if there was an unfair advantage taken or there was a detrimental use. We have extensive case law from the Court of Justice of the European Union. I just mentioned three decisions here that are very often quoted: the Arsenal ruling on commercial activity, the Celine ruling on trademark functions, and the Intel ruling establishing criteria for how to find and determine a commercial connection between marks. Based on this, I would like to quote, I like this quote from J. Phillips in his book on trademark law from 2003. Trademark law and practice as we know it today more or less started afresh in the mid-1990s with the establishment of the internationally accepted TRIPS norms, the implementation of the community trademark, and the Madrid Protocol system, and the introduction of federal anti-dilution laws in the United States. I think his statement is very right. In 2015, we had an update of the European trademark system, the trademark regulation and the directive, and that reform provided extended protection for goods in transit and labels and packaging. These two fields especially relevant to trademarks with a reputation. And the trademark directive almost fully harmonized trademark protection in the EU. We had that trend, of course, of harmonization through the previous directive and through the case law, but now almost a complete final step was taken. After TRIPS, the world has seen the rise of the internet, including the domain name system. We have almost now 400 million registered domain names in the domain name system with enormous impact on trademark law and protection and enforcement. We have the emergence of e-commerce, the rise of social media, elevating the ability of major brands to market their goods and services to an unprecedented global and commercial level. Now, that was the history, and my main point of the history is that the development of the law and the jurisprudence is very closely tied to societal changes, changes in trade and changes in commercial practices, and not least the rise of mass communication and media. Now, I'll introduce my own infringement typology here because it'll be a little bit significant when we move on in the presentation. It's purely qualitative slide. It's not quantitative in any way, and there are national legislative differences, especially in regards to the criminal comments that I will be making. First of all, we have trademark infringement. It's defined, the scope of that, in the trademark regulation and in the national trademark laws. And then we have counterfeits. That's defined in the TRIPS Convention as identical or essentially the same marks that are used for the registered goods and services. We can have replicas. This is not a legal term, but it's a term I would use if the counterfeit is trying to replicate a product that is being produced by the legitimate owner of the trademark. Not necessarily in quality, but in looks and appearance. And we can have fakes. Fakes are the use of the mark, but for goods that are not produced by the right holder. It can be inside the specialty, it can be outside the specialty. And we can, of course, we have the rules on parallel imports, and we can call them, if they are illegal, gray market goods. We also have overruns where a licensee is producing more than is in the licensing contract. That's usually a contractual conflict outside of the trademark infringement field. And then we have trademark crime, and that will very often cover counterfeits. In some instances, that can be a threshold. So maybe a few counterfeits will not constitute a criminal offense, but most counterfeits will fall under the scope of criminal law. And it can also cover other infringements. In practice, criminal cases will almost always feature pure counterfeits. I would say we rarely see criminal cases outside that field. It happens, but it's not that usual. And then we can have cyber criminal offenses, especially in regards to domain names or other uses of trademarks on the internet for hacking, phishing attacks, and other cyber criminal acts. And then we can have other related illegal acts or crimes, product safety violations, illegal marketing practices, fraud, tax evasion, VAT fraud, and money laundering. The last one, of course, of special relevance for this field where the profits are so immensely high. Turning to enforcement measures, we again take the starting point is the TRIPS Convention. The TRIPS Convention was the first time we had international minimum requirements for not only the protection, but the enforcement of intellectual property. The international legal framework had focused on protection issues before 1994. But with TRIPS, we introduced now enforcement measures as well. And in the EU for civil enforcement measures, we have them, as the previous speaker was indicating, a specific directive that sets up minimum requirements for that. I just mentioned three things. We already heard it. Injunctions, also targeting third parties is very, very important, perhaps the most important remedy available. Preservation of evidence, right of information, and for final measures, of course, the calculation of damages. I'll have a couple of examples, interesting examples of that. The obligation to pay legal costs for the losing party, corrective measures, and publication of judicial decisions. If we have administrative enforcement, TRIPS tells us that they should follow the principles of civil enforcement. And then very importantly, in TRIPS, we have minimum requirements for border measures, customs, customs measures. In the EU, we have had 3 updates of these rules, and they were last updated in 2013. There is the ability of the EU customs to take action after an application from the right holder, or they can take ex officio action. The rules covers all infringing acts. They're not limited to reputed trademarks or counterfeits, but in practice, counterfeits related to reputed trademarks prevails massively. I was just in July analyzing all the customs seizures from one specific country. And I had access to all of that data, and all of the detentions that had happened those 2 years, 2018 and 19, all of them were trademarks related to trademark with a reputation. And I would say almost all of them were pure counterfeits. So in practice, while not theoretically, in practice, that will be the kind of goods that normally is targeted by the customs authorities. Of course, really, really importantly, the new rules of goods in transit and the new labels and packaging rules are of huge importance to the customs procedure. It gave rise to a lot of problems for the customs authorities before, especially with the goods in transit, where their ability to take action was limited. These are very, very important new rules that we have got. For criminal measures, we do not have a specific EU instrument, but relies on TRIPS Article 61. And major national differences exist legislatively. I would say in practice, most criminal trademark cases concern trademarks with a reputation, both within or outside the specialty. And I mentioned replica counterfeits or fakes, and the fakes could be inside or outside the specialty, both of them. But most criminal cases will, if not all, almost all, will concern trademarks with a reputation. My case examples are certainly will illustrate that. Now, some people are of the view that there is kind of like a conflict between civil and criminal enforcement. Nothing could be further from the truth. The two means of enforcement are complementary. Some cases are better suited for civil procedure. Some cases are better suited for criminal procedure. I will mention a new development in the EU that is very significant. We have in the EU what we call the European Multidisciplinary Platform Against Criminal Threats. It sets EU law enforcement priorities and focuses on serious and organized crime and provides support to leadership and practitioner levels. It's intelligence-led and EU member state-driven cooperation instrument as part of coherent security ecosystem. The impact priorities up until 2017 included some limited parts of IP crime, but they are not in the current priorities. But in May of this year, the Council decided on the priorities for the next 4 years. And as sub-priority 7.4, It will from 2022 cover intellectual property crime, counterfeiting of goods and currencies. And this indicates that the Council has seen the necessity to give criminal enforcement of trademarks a higher priority. Now comes my case examples. As I said, my civil case examples are from Danish jurisprudence, and the criminal ones are more international. I have 4 cases. Well, I will cover a period of almost 20 years from the first decision 2005 and then up to a very recent decision. I have 4 cases about the same right, and that is Tivoli, and I will go over those 4 cases. Now, Tivoli, also known as Tivoli Garden, is an amusement park in Copenhagen, Denmark. I'm sure those of you who have been to Copenhagen have been to Tivoli. Every visitor that comes to Copenhagen goes to Tivoli Gardens. The park opened in 1843 and is the 3rd oldest operating amusement park in the world. With more than 5 million visitors, it is the most visited park in Scandinavia, and they hold numerous trademark registrations. I show you 3 of them at the bottom of the screen. I turn to the Danish Supreme Court ruling from 2005 concerning Jacobsen Bakeries. In 1954, SJ began a cookie business that evolved into the limited liability company Jacobsen Bakery. After beginning to market cookies using the Tivoli name and other Tivoli-related symbols and pictures, an agreement was reached in 1999 that the following could be used for a 3-year period against a licensing fee. And you see the nice picture of one of the buildings, very famous buildings, the Tivoli Gardens. The licensing payments were only made in 1999, and in 2001, Tivoli initiated infringement proceedings. The scope of sales of cookies was not fully established, but it was quite extensive. It probably had a value of several million euros per year. Tivoli claimed trademark infringement and demanded 700,000 euros in damages. The Commercial and Maritime Court found that Tivoli was an international icon and a global symbol of Copenhagen and Denmark, and the trademark was very well known and was protected outside the specialty. The use of the Tivoli logo took unfair advantage of the reputed nature of the trademark. Due to the uncertainty of the size of the sale, a lump sum damages of 130,000 euros were rewarded. The Supreme Court upheld the ruling but reduced the damages to 20,000 euros. The next case is one of my favorite infringement cases of all times. You can guess why. Innocent Pictures broadcasted pornographic television in the Copenhagen area from the 1st to the 20th of June 2007. 20th of June, the date of court injunction against the activity. Tivoli claimed 130,000 euros in damages and requested the imposition of a privately prosecuted criminal fine of 13,000 euros. It's a specific thing that can be done in a few countries where in a civil procedure, a criminal claim can also be brought forward. And this was done in this case. The Commercial and Maritime Court found that the use of the Tivoli logos were detrimental to the reputed nature of the Tivoli trademarks and awarded damages of 35,000 euros and imposed a fine of 7,000 euros. It was upheld in the Supreme Court. I turn to toilet seats. President produced products for toilets in 1954. A license agreement with Tivoli had been terminated in September 2011, but President continued to use this logo on toilet seats until the end of 2012, with a total value of the activities of around 140,000 euros. You see the logo here on the other side. Tivoli claimed damages in the form of a 5% license fee, and the court awarded exactly that. The last Tivoli case concerns furniture. Montana Furniture Limited Liability Company produced furniture. The production of Tivoli chairs had dated back to the 1950s. The facts of the case are very complicated. There had been a long and arduous commercial relationship between the companies. I won't summarize that here, but go to the conclusion. The Commercial and Maritime Court found that there had been a misuse of the reputed nature and goodwill associated with the Tivoli trademarks and awarded damages of 100,000 euros. It was upheld in the Supreme Court, but the damages were increased to 250,000 euros. Very often, right holders are complaining that the courts are not awarding high enough damages, but I think the examples I've given here, there's actually quite high calculation of damages, especially in cases with a previous commercial relationship between the parties. I turn to another case, the Noma case. The home enter company marketed chocolate products via a chocolate club using the name Noma in its advertising in a way that indicated a connection to the Noma restaurant. Now, Noma restaurant is one of the most famous restaurants in the world, and it's been hailed as the best restaurant in the world several times. It is currently hailed as the second best restaurant in the world. The Danish Commercial and Maritime Court and the Supreme Court found that the advertising had taken unfair advantage of the Noma brand and awarded the restaurant 20,000 euros in compensation, equivalent to a theoretical licensing fee. I turn to another little bit fun example of trademark infringement in the Cavalli case. We all know the Cavalli company from Italy. They have commercial activities in the field of luxury products and experiences and holds numerous trademark registrations, including this one. Cavalli nightclubs have a very specific and very luxurious style. The defendant had changed his name to Cavalli just before opening the Cavalli nightclub in Copenhagen in February 2015. The defendant used this logo at the nightclub. The court noted that the Cavalli trademark registrations covered the running of nightclubs, so we are inside the specialty. Quoting the Gillette ruling, the court found that the use of one's own name has to be compliant with fair marketing practices. The court found, after taking all the facts into consideration, that the defendant had wanted to create a commercial connection to the Cavalli company, and the court made a preliminary injunction prohibiting the use of the Cavalli logos in the nightclub. I guess the case was settled out of court after that. Turning to Asterix and Obelix, I will mention the case concerning the Café Obelix. So we are staying in a little bit the same field as the previous case. Le Édition Albert René Salle holds a number of Asterix and Obelix related trademarks. The defendant had run the Café Obelix since 2009 with extensive use of Asterix and Obelix names and symbols. Albert René claimed damages of 81,000 euros for the period 12 to 16, for which detailed information about the turnover was available, and they claimed 2.25% of the total turnover. That was in total 3,600,000 euros. The court found that the reputed nature of the trademark could be damaged, not least because alcohol was served in the cafe. The court awarded full damage claim. Again, here we see quite extensive following claims of the right holder actually in practice. My last case is from 2020 and concerns Louis Vuitton products, LVMH products, or brands, sorry. The rich recycled company produced supposedly environmentally friendly garments from materials bearing the well-known trademarks of LVMH, which were not recycled from original LVMH materials or products. So it was taking counterfeit Louis Vuitton products, recycling them and applying them on new garments and shoes. LVMH claimed that the marketing had been done in several physical shops and an e-shop for 1,228 days, and estimated that one pair of shoes at a price of 200 euros had been sold per day, and claimed 1,400 euros in damages per shoe, a total claim of 1,719,200 euros, but limited the total claim to 26,300. It's not unusual in cases like this that the claim is significantly reduced. The court found that the production, marketing, and sale constituted an infringement of LVMH trademarks, as the use resulted in an improper exploitation of the reputation. The fact that recycled products indicated I am not, to avoid immediate confusion with original products, did not justify the use of the marks. The court did not rule on whether the use have been justified if it had been original LVMH product that had been recycled or had fallen within the scope of exhaustion. So we will have to wait to see that maybe in another case. A lump sum of 10,000 euros was awarded as damages. Just a comment on criminal cases before I will give you case examples. Most criminal trademark cases, as I said, concern trademark with a reputation, but usually with identical or similar goods, counterfeits, but they also exist outside the specialty. As symbols of society and culture and key components of the economy, reputed trademarks have become attractive for the misuse by organized criminal groups. The reputed nature of trademarks often has an impact on the willingness to allocate resources, as the loss to businesses and society and the implication for consumers can be significant. Also significant is the rise of e-commerce, where the consumer seeking goods from reputed producers cannot rely on the trading situation, appearance of the store, or am able to inspect the goods in practice before the purchase. Equally important is that organized intellectual property crime cases and a significant number of e-commerce cases cannot be investigated effectively outside the criminal system. I turn to one of the most important criminal trademark cases in European case history, and that is the Swedish Supreme Court ruling in the SKF case. A Chinese company had produced counterfeit ball bearings that was marketed in Sweden by the Transmission Team Limited Liability Company up until 2010. Criminal liability was found based on the defendant's many years of work in the ball bearings business, correspondence between him and the Chinese producers, and other pieces of evidence. Interestingly, which is one of the reasons why this is such a seminally important ruling, is that the Supreme Court disagreed with the Svea Court of Appeal that the penal value of an infringement should only reflect the direct damage to the brand, not the damage to third parties. I think here we see one of the differences between criminal procedures and civil procedures. The criminal procedure more takes the general negative impact of the crime on society into consideration, not only the negative impact on the individual right holder, where the civil proceedings will usually more focus on the loss of that specific holder of the right, as also illustrated by my civil examples. But the criminal cases take a little bit of broader societal perspective. In the first instance, court was given a 1-year imprisonment. It was reduced in the appeal court to 4 months suspended prison sentence, and the main offender received in the Supreme Court 8 months suspended prison sentence. The Gomorrah case is one of the biggest criminal investigations into counterfeit products we have seen. Substandard power tools not compliant with EU safety standards were imported to and reworked in Italy and Spain. Reworking means that you apply the logo and the labels of the reputed trademarks inside Europe. So importation of unbranded or goods, and then the application of the reputed trademarks inside Europe. Why is that being done? Well, it's being done to bypass the customs control, because customs cannot take action against, or will certainly have more difficulty taking action against the power tools if the trademarks are not applied on them. Maybe they could have used the safety rules, but again, that would be quite complicated to do. So at least the IP rules and the IP regulation for enforcement would not be applicable. There were sales all over Europe for a long period of time, and it was run by a traditional mafia organization originating in Naples and comprising of more than 60 persons and several limited liability companies. There was extensive money laundering through Australia and Iceland. There was the involvement of law enforcement agencies in 20 countries, Europol and Eurojust. 67 arrests, lots of searches, tons of counterfeits confiscated, and also confiscation of assets. 6 court proceedings in different countries with sentences of more than 6 years in prison. It emphasized the importance of the new rules on labels and packaging especially relevant for reputed trademark. And I think we can agree a case like this could not be dealt with in the civil procedure. That would be impossible. Only criminal procedure could be used against this kind of organized criminal activity. The same goes for the Vigorali case. There was distribution of unregulated and counterfeit pharmaceuticals from India and China via 50 web pages allowing payment by credit cards. Criminal organization was based in Austria, and there was distribution to customers in Spain and Austria via dropshippers in the UK. Investigation in several countries, also involving Europol and Eurojust, lots of arrests, searches, lots of pills confiscated, and also assets. Investigation included phone interceptions, advanced IT investigation, and the use of the TrueScan device. You can see it over here, that is able to detect the chemical composition of a pharmaceutical. 6 main defendants, charges of fraud, infringement of medicine legislation, counterfeiting, money laundering, etc. Sentences up to 5.5 years imprisonment. Emphasized the importance of criminal procedure due to complex collection of evidence in transporter e-commerce cases. The last case is very recent from Belgium, the Facebook case. Marketing of mainly counterfeit clothing via Facebook and Instagram, and distribution from self-storage facility in Belgium in May 2015. Cyber Patrol investigation also involving cooperation with internet intermediaries. The defendant was convicted for sale of fewer than 100 Nike, Bjorn Borg, and Philip Klein counterfeits. 3 months suspended prison sentence. It emphasizes this case the importance of cyber patrol and the easy access for law enforcement to obtain evidences from tech giants. Generally, law enforcement and in a criminal procedure, it is easier to access cross-border evidences. And especially from these kinds of tech giants like Facebook, it's a very easy procedure to get the evidences for the use in the case. And that leads me to the conclusions and my slide that I hope you will enjoy, because I actually spent quite a lot of time making it. I will try to look and conclude in 3 levels: society and economy, the protection level, and the enforcement level. And I think they're connected to each other. We saw in the beginning technological and societal developments that fueled the emergence of strong international brands. That led to a movement from strict speciality to the recognition of dilution and tarnishment. And we saw extensive civil infringement jurisprudence developing in Europe and in the US. Now, in the 1950s, we saw the rise of electronic mass media, and we saw the rise of advertising. As a result of many things, we got an update of the Paris Convention, and then we saw for the last 30 years the rise of globalization. And that led to the TRIPS agreement, and with the rise of the internal market in the EU, we got the creation of the European trademark system. TRIPS also included enforcement measures, and we have them implemented in EU law through the customs regulations up until 2013, where it was updated last, and the Civil Enforcement Directive. And now we have seen the rise of the internet, social media, and e-commerce, not least in the last year. Through COVID, we've seen this explosion of e-commerce. It would probably have come anyway, but it's been fueled and accelerated by the COVID crisis. That has led to extensive EU, not only from the Court of Justice of the European Union, but also from national courts, extensive jurisprudence. And we have seen an increased protection level in the new regulation and directive, especially in regards to goods in transit and labels on packaging. That is so important for reputed trademark. And now, as the very latest, we see, as a result of all this, that higher priority will be given to criminal enforcement of intellectual property. And that will be my concluding remarks. And I thank you very much for your attention. And I will be happy to answer any question or listen to any of your comments. Thank you.
Thank you, Mr. Vestergaard. Actually, we have one question to you. The question is in Latvian, but I will try to translate it in English. The question is such a one. In criminal cases, who usually establishes a fact that the trademark has a reputation? And by whom I mean, is it courts themselves or what institution? Okay.
In a criminal case, it falls upon the prosecutor to prove any element that is relevant to the case. So it will fall upon the prosecutor to prove the reputation. In practice, I don't think it's any problem because, as you already saw from my examples, it is undebatable that all of the brands that I mentioned earlier have a very, very high level of reputation. So in practice, I would actually say the court will do it themselves, and it will usually not be any big issue to prove that. But theoretically, if it came up as a point of conflict in the case, it would fall upon the prosecutor to prove it. And there would usually be the determination of evidences is free, usually. So any piece of evidence that could be used to prove that would be able to be used in most of the proceedings. But it's a very good question.
Thank you, Mr. Vestergaard. And actually, one more question to you. In your presentation, you mentioned two terms: well-known trademark, also used in Paris Convention and TRIPS agreement, and trademark with reputation, used in European Trademark Regulation and also in directive. What is your opinion? Does it mean the same, or is there any difference between well-known trademark and mark with reputation?
In European law, it substantially is the same, but a well-known mark is not registered, and the trademark with a reputation is registered. But as for content, it will be more or less the same.
Okay, thank you very much, Mr. Vestergaard, for your presentation and also for answering your questions.
And now we are going to the next point in our agenda. The next lecturer also represents the Office of European Office, the appellate boards. And his name is Christoph Bartos, who studied at the University of Vienna and University of Paris, and since 2000 works in the European office. Started as assistant and then became the assistant of the president, and since 2011 is member of the boards of appeal. He will speak about the decisions of the European courts, EU courts, and also the office about the comparison of services, identity, and similarities.
Good morning. I hope you can hear me now.
Yes, we can hear you.
So, good morning to all of you. I would like to welcome. Wait, I just have to turn off the translation because I have it still on my. Just a second. Okay, so thanks a lot, and I'm sorry for these small technical problems. No, it's still. So I hope now I got off the translation because I had it on my headphones. So good morning to all of you, and I would like to welcome you to this short speech about EU and EUIPO and Court of Justice case law regarding the NIS classification. First of all, I would like to thank you and would like to thank the organizers for inviting me. It's a pleasure for me to be with you. Of course, I'm sitting here today in sunny Alicante, but still I would have loved to join you at home in Latvia and to enjoy a little bit more better weather than we do have here. You might think this is wrong. Yes, we have sun here, heat, but after 3 months of constant summer, I would have appreciated a small breeze of fresh air, which you apparently have today at home. So before I start with my presentation, I would like just to tell you that we will have included into this presentation a small quiz. This is on the special request of one of the participants of this conference of today. And yeah, the first hint, you will get 5 of them, you see currently on the screen. It's the village of Benillup, and I will give you more hints. It's in the province of Alicante. But it's up to you to find out what is the connection of Benillup with probably some other places coming up today. So what are we going to speak about? We will speak about the application procedure, the comparison of goods and services, and the use of a trademark. In all these aspects, the classification of goods and services plays a very important role. So before we go to the application process, a second hint. It's again Confrides now. Confrides is also a very small, wonderful town, as you can see, in the province of Alicante. So, any clue what is the connection between Benillup and Confrides? But let's go into medias res and the application procedure. Just as a small hint to you, when you apply a trademark, irrelevant whether you are a practitioner constantly applying for trademarks, or if you're just a private entity, private company, a private person, and you would like to apply for your trademark, please use our online tool. This will help you to get the best out of the system, and it will help you to classify your list of goods and services correctly. You have on the screen now how this page looks like. It goes on. You have to add the goods and services. And of course, you can go there and use our online tool where you search for specific terms and you will get this term already classified and you just accept that. This is, as an example, the list. You put in class headings and you can then add one by one the goods and services you want. But if we speak about the classification, about goods and services, one important thing is it's just an administrative purpose. The goods and services, as you know, are classified in 45 classes according to the NIS classification. But this serves only administrative purposes, and goods and services belonging to the same class are not necessarily similar because they are in the same class. Neither are they dissimilar because they belong to a different class. When you apply, please remember always what is your current interest in your trademark. So what are you doing? What are your current ideas, your current plan, and apply for these goods and services? You can always think, and that's a good idea, about future possibilities. What is really within the possibilities that you expand? So don't be too shy, go a little bit further. But please remember, when you go further than what you're doing, it has an impact on possible trademark conflicts. It opens you to become vulnerable on the market because other companies may feel you are touching their territory. Also important is goods and services need to be offered to third parties. Any internal use is totally irrelevant and is not protected by trademark law. The next important thing is, of course, the goods and services needs to be clear and precise. Why? That's an easy reply in reality, because anybody needs to know what it is. So when we assess the registerability of a trademark, we need to know whether what it is. A term which is not clear and precise, we can't object with respect to possible descriptive or non-distinctive character. If I do not know what exactly it is, I can't link this term or the meaning of this term with the goods and services. It's also important for any other third party. Your trademark application is published, so the register, and once it is in the register, third parties, any other undertaking on the market must know or must be able to know what is the exact scope of protection granted to your application. So therefore, this is also important, and that's why we need to have clear and precise terms. So clear and precise class headings can be clear and precise, provided can be used, provided that the term used in the class heading is clear and precise. And then, of course, we have orphans. What this means, I will explain you in the next slide. And then we still have orphans. These are all terms which belong in the alphabetical list, but are not part of one of the terms in the class heading. So let's take class 15, which is protected for music instruments, but you have music stands also in the alphabetical list. A music stand is not a musical instrument, but still it belongs to class 15 and is a so-called orphan. Terms which appear in the class headings and which are neither clear nor precise. This is especially everything which is goods of, you have this in class 6, 14, 16, 17, 18, and 20. Especially in class 20, you have goods made of leather. But what is a good made of leather? A product made of leather can be many different things, such as a bag, a suitcase, a whip, a walking stick probably. So this is not clear and precise. Machines in class 7, you have many different types of machines in class 7. In class 37, repair is an example of what? Of shoes, of cars, of computers. You can't say that these repair services have something in common because it's just repairing. But the knowledge you need, the machinery you need, and the place in which you can offer these services are totally different. So therefore, the same applies also to installation services. Treatment of material as an example. What material is treated? How do you treat the material? Also important. And we'll come later on to class 45, which is the personal and social services rendered by others to meet the needs of individuals. This is one of my most favorite class headings. And you will see later on why it is like that. What are the reasons, or what is the consequence if a term is not being clear or neither precise? How can you compare something? How can you compare goods made of leather with something else if you do not need what it is? Is it identical, similar, dissimilar? No possibility. Then we do have the problem, what happens if something goes to the register despite the fact it's not being clear and precise? What do we do with that? So there is important in Lambretta, the court said that the judgment IP translator, the one about clear and precise, is only applicable to applications which were applied for after rendering the IP translator case. This is a quite interesting approach because IP translator interprets the law. So it says what was the law from the beginning. It does not change it. So normally, my personal opinion is such an interpretation has, of course, retroactive effect because it was always the law. Here the court says, no, it's only applicable as of that date. And this leads, of course, to the problem, what do we do with trademarks once they are registered? Probably also before the date of IP translator. What can we do about that? Or afterwards? And here in Sky, the court said, no, there's no invalidation ground to get such a trademark out of the register. This can be only done in revocation proceedings about the non-use or the use of a trademark. So first, no comparison possible, IP translator not applicable, and no invalidation ground exists. This, of course, might lead to some weird situations. What do we do at the end if we can't do anything? Normally, we then go to the detriment of the party who uses such a broad term, which is not clear and precise. So this means on the side of the application, it goes to the detriment of the applicant. So there will be more risk of similarity of goods and services. On the other side, if it's the opponent, there we will say we can't compare it and go to the detriment of him and say that there might not be any likelihood of confusion. If you apply class headings, you have here two examples. One recent, Tokyo 2020, an international registration. On the other one side, you have Mercedes-Benz, a very old one. Both trademarks are registered for class headings in all classes which were applicable at that time of the application. Mercedes-Benz back in 1996, 42 classes, Tokyo 2020 in 45 classes. Is this really needed? Is this the need of Mercedes-Benz or the Olympic Games? I don't think so. Another example, Red Bull as an example. Everybody knows Red Bull. It has, until recent, it had only one product on the market that was energy drinks. Now it expanded a little bit to other drinks. It goes also beyond it already. It has also, in Austria at least, a telecommunication company, mobile phone company. But still, is it necessary to register it for this product you see now on the screen? You might wonder what it is. It's plutonium. It's registered for nitrate of uranium, plutonium, and heavy water. 3 products you only use in nuclear power plants. On the other side, Muji, there you have the final product, a nuclear power plant. Muji is registered for nuclear power plants in class 11. Do they need it? I don't believe so. So be clear, precise, and don't go too broad. And now we are coming to class 45, to personal and social services rendered by others to meet the needs of individuals. And this includes 3 subcategories in reality, which are religious services, dating services, and funeral services. Both trademarks you see here also on the screen, Amazon and Bayer Leverkusen, the football club, are also registered for these services. Of course, some might believe that football is a religion, but still I don't think so that football falls under funeral services or should fall under funeral services. You might meet your partner of life at the football pitch, might be possible, so therefore it could be dating services. But this is really far stretched, and I'm just surprised that 243 trademarks registered are for all these 3 services, namely exactly like that. And most of them are coming from one company, namely Sky, the TV station. Another problem you do face is, of course, broad terms. As an example, alcoholic beverages. This is very broad. It does not only include wine, liquor, and spirits, but also other drinks of lower level of alcohol, as an example of cider. Does it fall under wine, liquor, and spirits? I don't think so. But still, it belongs to class 33. One more important thing here is alcoholic beverages. When you speak colloquial about it, this includes also beer. However, beer is not classified in class 33, but only in class 32 with non-alcoholic beverages. So you see that sometimes the colloquial language does not have to do anything together with the language of the NIS classification. Retail services also important. What are retail services? The object of retail services is the sale of goods to consumers. And this includes, in addition to the legal sales transaction, all activities carried out by the trader for the purpose of encouraging the conclusion of such transaction. This means selecting of an assortment of the goods. It has also accessory service, further accessory services, namely mostly including to the consumer to conclude the transaction, which is informing you, giving you help, being there for you, ordering specific goods you want to have, or even financing it. All this falls under the retail services. And when you apply for retail services, it's important that you specify for which goods and services you want to retail or you are retailing. However, it is not necessary to exactly specify eggs, milk, cheese, whatever exactly it is. You can go back to a common approach and say retailing in foodstuff. This would be sufficient. Retailing in clothing. You don't have to say which type of clothing. Retailing in shoes. All this is fine. Retailing in pharmaceutical products. So therefore, this is important to know. On the other side, we have again here one judgment, Burlington, which says that practica is only applicable to any application made after the date of the practica judgment. It's the same like in DP Translator. You have to be careful also when you put some specific wording into your list of goods and services. Many times we see the term namely, we have also especially or including. However, is alcoholic beverages, namely red wine, the same like alcoholic beverages, especially or including red wine? Of course not, because on the one side, with namely, you have only red wine, while on the other side, you have any alcoholic beverages, and additionally, you have red wine also requested. The same thing can very often happen, which changes totally your level of protection when you use a comma, a semicolon, or a full stop. So the example, hardware, comma, software, comma, namely for printers only, reduces protection for printers. Namely, both hardware full stop, software, comma, namely for printers only. Then you have any hardware for computers, which includes the computer itself, servers, printers, screens, but the software is only for printer. So this is very important to take into consideration. Another important thing is when you speak about list of goods and services, that you cannot exclude specific characteristics. What does this mean? Can you register furniture not for use in post offices, or maps not for hiking, wine not for sale in Latvia. No, all these specifications would not be acceptable. You can't exclude that furniture shall not be used in post offices. A table, a chair might be used in a normal office, at home, in a restaurant, or in the post office. Cannot be excluded. Maps not for hiking. This is also not possible because for hiking you don't need a specific map. There are specific maps on the market, I do know, but you can use a normal driving map, an atlas. All that can be used also for hiking because it gives you sufficient information to perform this. And wine not for sale in Latvia is also an example because you can't exclude that this product is sold in Latvia. But what's about the other examples here? Maps not for aviation or wine not made in Sweden. Yeah, these are most probably exclusions which are possible. Why is there a difference between maps not for aviation and maps not for hiking? Have you ever seen a map for aviation? This looks totally different. You don't have any indications about lines, altitude lines, things like that. You have totally different indications regarding, you don't find streets on it normally. You find air streets, so the corridors in which you can fly. So this looks totally different. The same wine not made in Sweden is just the place where it is produced. This can be excluded because I produce only in Austria my wine. So therefore I can exclude any other country where it could be produced. And this differs it from not for the sale, because the sale is something which goes after the production, after it's made, and not anymore in the control of the trademark owner. Next point, be precise also. Ice itself is something nice, but what is it meant with ice? Do you mean ice cubes? Or do you mean ice cream? Two different products. If you speak about CD-ROMs, be clear and precise. What do you want? Do you want to have CD-ROMs, which are empty? Or do you want to have recorded CD-ROMs? On recorded CD-ROMs, you have already something, either music, video, software, whatever, but there's already something on it. If you use only the term CD-ROMs, this office will consider this as an empty CD-ROM, which can be used to store data for everybody, and not already pre-recorded CD-ROMs. Also, it is important to remember that the classification of a product in specific laws, whether it falls under pharmaceutical law, whether it's an alcoholic beverage, etc., does not have any impact at the end of the day in the classification system. These are two different approaches, two different things. And therefore, just because it's classified as a pharmaceutical product in accordance with pharmaceutical law or labeling law, it does not mean that it's a pharmaceutical product in class 5. So be careful about that also. And last but not least, here we do have the situation that we have some products which fall in multiple classes. As an example, you have on the screen shoes. You have protective shoe wear in class 9. It's an interesting class 9, by the way, because you have on the one side technical products, computers, and protective wear. And on the other side, these protective wears. Shoes can also fall under class 10, orthopedic shoes. These are shoes specially designed for the needs of people who have problems in walking, different lengths of legs. They need specific help for the ankles, all that. And class 25, you have the normal shoe wear, which is everyday use. So therefore, shoes itself is unclear. And you have to specify always the class you want to have. So be careful Not because you see shoe, think about what you want to have. Clothing goes even further. Clothing falls in 5 different classes. You have protective clothing in class 9. You have medical clothing, surgical clothing in class 10. You have clothing for dogs in class 18. You have clothing for humans in class 25. And you have clothing for dolls in class 28. So think about what clothing you do want to have. And then think before registering again. That's something I want to tell you. Do not make yourself vulnerable. 2 classes which are constantly used by many applicants, and I doubt that these applicants are really going to use these trademarks they're applying for. It's class 35 and advertising, and class 38 telecommunication. 10 days ago, we had 220,267 registered EUTMs for advertising. This is a share of 16.2% of all registered trademarks. Direct trademarks are registered for advertising, which means every 7th trademark is registered for advertising. Just because you advertise your own products, you are not offering advertising service. Advertising services are services offered by a company for third parties, for someone else. And the same applies to telecommunication. We have nearly 100,000 registered trademarks for telecommunication. I know that the telecommunication sector is broad, wide, big, and important, but I don't think so that every 15th trademark registered really offers telecommunication services. This is also if you have internal telecommunication, if you offer your service on the internet, you are not a telecommunication provider. Telecommunication providers are those who offer the service of telecommunication with a telecommunication network. Might it be a real telecommunication network or a virtual telecommunication network because they rent of a real telecommunication provider. But it's not a company who offers its own products on the internet, who offers a blog on the internet or whatever, and therefore these would be out. And last but not least, in the classification, it's not even last but not least, also a very important point, please do not use the name of other trademarks in your trademark application. 2 probably famous trademarks, aspirin and Segway. I found one trademark which includes aspirin in class 5 as the specification of the list of goods and services, namely in pharma house. What should have been put here? Probably headache pills or other pharmaceutical preparation. On the other side, you do have Elvilo, which has in class 12 Segways. No, Segway is not the correct term. It's a 2-wheeled self-balancing personal transporter. So please avoid these terms when you apply your trademark. And if you're an owner and you know that your trademark is famous, check the register constantly whether someone has applied for and request deleting it. Otherwise, you run the risk that your trademark becomes vulgarized, which means it's becoming the common term for a specific product. And this would make it liable to be revoked. So be careful about that on both sides. And yes, now we are going last but not least in the application process. You can limit or restrict your trademarks at any time, your specification. Important is it's at any time possible, even after registration, it must be expressly and unconditional. So you can't say, I suggest to reduce, to limit my application in case you would consider that there exists likelihood of confusion. No. I could limit my application to is not expressly. It's a possibility. You just say could. I will, I want. This is the correct wording. So now let's go to the comparison of goods and services. But we still have a photograph here. Yes, also the province of Alicante can have snow. And here you see the village of Formarca, also in the province of Alicante. So, any idea what connects Benillup, Confrides, and Famorca? Let's go to the comparison of goods and services. When you compare goods and services to find out whether there is identity or similarity, you take into consideration nature, intended purpose, method of use, and consumers, whether the goods and services are in competition or whether they are complementary. And probably any other argument, criteria you find suitable for you. What means in competition? In competition means that you can use one product or the other. You can use meat from veal, from pork, from chicken. You can use salmon or tuna fish. You can use an apple or a pear. All these products are in competition with each other. Complementarity is also a little bit more difficult, but at the beginning, it's important to know it needs to be in close connection, the goods, and one is indispensable or important for the use of the other in such a way that consumers may think that the responsibility for the production of these goods lies with the same undertaking. What this exactly means, we'll come to it a little bit later. So, example, water. What's the nature of water? What's the intended purpose, the method of use, and the end consumer? The nature of water is it is liquid. The intended purpose is to squeeze thirst. The method of use is drinking. And the end consumer is the general public. So these are important examples here. Clothing on the one side and underwear on the other. Is this similar, dissimilar, identical? This is identical. The court held that from the very beginning that if the goods of the trademark applied for are included in the list of goods of the earlier trademark, this leads automatically to identity. But what's about the reverse side? You have underwear in the application, the earlier good is clothing. Is this also identical? Yes. The court confirmed in the same judgment that this is also identical. What's about leather imitation? Leather and leather imitation on the one side in class 18, and on the other side, goods made of leather and imitation of leather. Do we have similarity? If we look now back to our list, nature, intended purpose, method of use, and consumers, in competition, complementary, the court held that these goods are dissimilar. Because on the one side, we have raw material, and on the other side, we have a finalized end product. Normally, with leather and leather imitation, someone buying leather and leather imitation is not someone who will go home with that product and make its bag itself at home. This is not normal. They are also sold in different outlets. They are addressed to different consumers in reality. So therefore, dissimilarity. However, is this always the same situation if you have raw material and a final product? I wouldn't say it like that. you have to use a little bit of logic behind it and what you as an end consumer is doing. If you take as an example, flour, eggs, these are products you use at home, you buy them, and you make a cake at home. You get cake preparation at home in the supermarket, which you have to finalize with mixing it up with other products. And you can do your cake from the scratch, from the beginning at home. So therefore, all these things are still, there's some similarity. But it's an important point to take into consideration. When we speak about complementarity, we have on the one side, we have sunglasses, and on the other, also in the applications, ski glasses and protective eyewear for sports. That's the application. And on the other side, we do have clothing. Is there similarity? The court said, first of all, that sunglasses and clothing, according to constant case law, is not similar because they are not even complementary. Why? Complementarity, we said before, is something which is indispensable, one for the other, so that consumer may believe that they are coming from the same undertaking, the goods. Eyewear, you're normally not using or choosing your eyewear depending of your clothing. So you're not using, because you wear today a Hugo Boss shirt, a Hugo Boss sunglass, or because you have a Louis Vuitton clothing, a Louis Vuitton sunglass. I don't know whether this exists, but as an example. So therefore, this is not something, at least nowadays, it's not like that for the most or the bigger part of the public. Some fashion victims, so-called fashion victims, may do so, but not the normal consumer. On the other side, we have ski glasses and protective eyewear for sports. This is, as an example, with ski clothing, includes also ski clothing. And if you go to a sports shop, you will get ski clothing, and next to it, you will get, of course, some ski glasses. So therefore, they are also often produced by the same undertakings. And this is something the consumer looks for in the same stores. So therefore, there is some complementarity. While you have specific stores for sunglasses or any glass, you don't have specific stores where you buy ski glasses. It's the same store where you buy ski clothing. Next example, software for booking hotels and hotel services. Who are the consumers of these goods, of the software for booking hotels? Software for booking hotels is not addressed at the general public who wants to book a hotel. The software for booking hotel is addressed to hotel companies, to a hotel, to a provider, so that someone else can book the hotel. Hotel services in class 42 is addressed to the general public. So therefore you get the conclusion already. It's addressed to different publics, and since it's addressed to different publics, it is dissimilar because they cannot compete on the market, on the same market. Retail services. Retailing of product, whatever, against exactly that product. Is this similar? Yes, there's similarity, and depending on the case law, you have two different case law here written on this screen. It is either average similar or lowly similar. My personal opinion is it is at least average similar. Why? Because the consumer at the end of the day, he doesn't care whether he goes to a specific store where only the product of one company is sold, or it goes to a retailer where it gets a variety of different, of the same product, but from different companies. Probably with Apple, this is not good now to explain, but if you take clothing, you might go to a store, to Zara, to Mango, H&M, C&A, whatever, and you get clothing there. But you get it only from that company. So you want to have clothing. You might go to a big retailer where you get different products. Here in Spain, we have as an example Corte-Inglés, which is the biggest retailer. So you will get products from many different companies. What's about retailing of a specific product against retailing of a similar product? Is this still similar, or is this dissimilar? Difficult to answer. It depends most probably how far are they removed. The more specific the wording is, the more far it will be probably. But if it's just in a general approach, it might be still some similarity. Retail versus retail, just because it's retailing, this does not mean that there is a similarity. So retailing of foodstuff is of course dissimilar of retailing of pharmaceutical products. Something which is always, or very often popping up in opposition cases or in cancellation cases is the comparison of drinks, of beverages. Beer against wine as an example. I told you already before, we have beer in class 32 and we have wine in class 33. Nature, both are liquids, intended purpose. You drink it. Why do you drink it? The nature of use. You drink it to squeeze thirst, not necessarily, but to have a nice dinner, to accompany probably a nice dinner. Addressed to the same public, namely those drinking or allowed to drink alcohol. They're in competition. You might drink a wine, you might drink a beer next day, or even at the same place. So therefore, of course, despite of two different classes, there is some similarity. What's about water, mineral water, and vodka? Both are liquid, but you will never drink vodka to squeeze your thirst, or at least not in Austria or in Spain. I don't know how this is in the Baltic countries, but I believe it's the same. You don't drink it just to squeeze your thirst. Despite the fact that water is a very important raw material in the process of making vodka, it is a dissimilar product. What's now between mineral water and alcoholic beverages, or non-alcoholic beverages and alcoholic beverages? Here the court said already 10 years ago that there is some similarity because it is a product for drinking. Is this in contradiction to the case of vodka before? I don't think so. Vodka is a product with a high alcoholic content, 40 degrees above, while alcoholic beverages include drinks like cider, which has a very low level of alcoholic beverages. In this case, you see here now, we have the same situation. Also the Board of Appeal confirmed, due to the case before, that there is some similarity. This is now pending currently before the General Court, and the General Court will render a judgment, I think, next week on the 22nd of, so Wednesday next week. It's also this question pending currently before the Grand Board of this office. In this connection, it's important to remember also that non-alcoholic beverages include products which are becoming more and more important. You have non-alcoholic wine, you have non-alcoholic spirits. And I've even seen now that the same company producing gin, a famous company producing gin, produces a non-alcoholic gin version. Normally, for production of non-alcoholic products, you need to have first the alcoholic product, and then you You get rid of the alcohol content by specific processes. So therefore, it will be interesting to see how the court and the grant board will deal with these questions. Products of daily life, foodstuff. Most foodstuffs are similar. Here we have specific foodstuff, namely eggs and meat, ham, sausages. Also here the board said, and the court confirmed this, that these products are similar because eggs can be bought normally in butchers' shops. Pharmaceuticals against cosmetics. Is there similarity? Constant case law indicates that there is some similarity because the purpose of certain pharmaceutical products are, as an example, skin or hair care preparations with medical properties to help the appearance of a person. And that's the same aim, the same purpose as cosmetic products.
Mr. Bartos?
Additionally,
sorry, Mr.
yes.
Bartos, you have 2 minutes for your presentation because we should keep on the schedule. 2 minutes for your presentation, and then there will be some questions for you. Yeah, okay?
Okay, sorry.
Yeah, thank you.
There is, of course, some similarity because they are also sold in the same stores. You can see here several cases which are about similarity. I will skip all these things because I want to go to use. This is important. When you use a trademark, you have to use it within 5 years after registration. And you have to use it for the goods and services for which it is registered. So if you have clothing, footwear, headwear, and you've used it only for clothing, you will lose footwear, headwear. But how does this work with subgroups? As an example, you have financial services registered. You use it for real estate services, which falls under financial services, but you've not used it for any other financial service. You will lose all the others. You will keep real estate services. Example for clothing. You have t-shirts for men. You have polo shirts for men, underwear for men, shorts for men, socks for men. So what have you used? Not clothing in general. You've used clothing for men. You have bodies, slips for men, slips for women, bras, undershirts for men. These are all different types of underwear. So most probably your registration will be reduced to underwear. You have used blouses for women, slips for men, hosiery, jackets and skirts. This is a mix of different kinds of clothing. So most probably in this situation, you will keep clothing. You have further examples here on the screen, and you will get the presentation later on. It's also important to remind you that you have to use your trademark for the product exactly you have registered, not for a similar product. If you have wine and whiskey registered and you use it for gin, I'm sorry, it's not whiskey. While whiskey and gin are both spirits, gin is not a whiskey. So therefore, you will not get protection for that. So with that, I will close my presentation. Last village you will see is El Castel de Guadalest. My final remarks are, if you need more help, please check all these online tools we do have available for you. And my last question now to you is, what do these 5 villages have in common? You have seen Benillob, Confrides, Famorca, Benifador, and Castel de Guadalest. These are the only 5 villages in the province of Alicante which are still until today, or until yesterday, COVID-free zones, which means there had been not a single case of COVID in one of these 5 villages so far in all the past 18 months. I hope that you are still fine, healthy, and I would like to thank for your attention.
Thank you, Mr. Bartos, for your presentation. There's so many examples, but actually, as you also already said, this presentation will be available for every participant in PDF format, and then the participants can study the cases actually. Yeah? Now, I have 2 questions for you. Are you ready?
Mm-hmm. Yes, I'm
Yeah.
ready.
Yeah. The first question is such one. Speaking about unnecessary goods in the list of goods and services, how would you recommend an applicant having growing business but not yet a trademark with reputation to defend his trademark against persons who try to use his trademark for goods which are not similar but clearly unfairly exploiting growing popularity of his mark? Okay.
Okay. That's a good question, because normally if it's dissimilar goods, you will fail with Article 8.1b, likelihood of confusion. So therefore, it is difficult. You might go, if you had some business relation with that person and he's trying to expand it and use it, you might go with an agent's trademark. You might even get into bad faith, but it's very difficult to prove bad faith in agent's trademarks. So it is a problem, I understand. You have to build up already as much as possible, especially if you work on a small market, that you have at least some level of recognition, some higher level of knowledge of people, that your trademark is representing some specificity, and that you try to go via 8.5 and try to bring in as much as evidence as possible for that. Otherwise, I would not know how you can do it. I'm sorry for that, because it's really difficult, and I understand this is a big problem for many companies.
Okay, thank you very much. And then the next question is about similarity tool, which has been used by European Intellectual Property Office. And the question is, can you comment the use of similarity tool by European Intellectual Property Office versus personal approach, which has been used by some member states at least, in comparison of the goods and services? Okay.
Okay. The similarity tool is, let's start it like that. You know that the first instance is bound by the guidelines. The first instance has to work on instructions, and these instructions are guidelines. The similarity tool is part of the guidelines for the examiners. So therefore, if the similarity tool indicates similarity of specific goods and services, then that person has to follow that approach. If that person sitting and deciding on an opposition or cancellation request is of a different opinion because of evidence submitted or because of personal use, he has to go up the hierarchy and request authorization in reality to overrule, to overgo that tool. So therefore, under normal circumstances, you will find the decisions of the first instance will follow to 99.9% the similarity tool. The situation changes when it comes then to the boards of appeal. As you know, the boards of appeal are independent in deciding on appeals, which means that they are not bound by guidelines or instructions of the office. So for us, it is an indication about the situation. If we do not have, or at least I can speak only now about my own experience, if I have doubts, I will check it. What says the similarity tool? What are these arguments given there for being similar? However, if I have good arguments of the parties, I might still come to a different conclusion. So therefore, the similarity tool is a very useful tool, also for you to know whether you're running the risk of it's declared that the goods and services are similar or dissimilar. But if you believe that you should have a different result, then please argue in detail, bring evidence, especially if you speak about goods and services which are not so common. So if you speak about class 1 chemical products, this is something nobody in this office has real clear knowledge about it. So we need help to understand it. Specific products in class 6, 7, all 8, all that is products which are not used normally by us. However, if you speak about pharmaceuticals yes, we have some knowledge or idea for what it helps, what it is, foodstuff, etc. This is something clothing we have all experienced. So a very useful tool, which is used by our office on the first level as an obligatory tool, and on the second instance, and most probably also at the court level as an indication. Just to add a third point from my side now, if you have any questions, you will have in my presentation my telephone number, my email number. You can always come back to me if you have questions later on and ask them. Thanks a lot.
Thank you, Mr. Bartos, for your presentation, also for answering the questions.
And now we will have a break. Instead of 30 minutes, we'll have only 15 minutes, and see you at 1:02. Thank you to everyone.